Good morning, everyone, and welcome back to the BICL webinar series on sea level rise. My name is Jean-Pierre Gauci. I'm the Arthur Watts Senior Research Fellow in Public International Law, and it is my great pleasure to welcome you back to the series and to today's webinar on climate displacement. I just have a few kind of logistical things to mention at the beginning, and then I will hand over to Dr. Ioane Antonopoulos, who will be chairing today's session. Let me just start by saying a number of thank yous. First of all, to Landmark Chambers for supporting this webinar series, and to BICL for convening it, in particular the BICL events team, Bradley and Carmel, who were responsible for registrations, and Liam, who is our events manager and responsible for everything to do with Zoom at BICL. I also wanted to take the opportunity to remind everyone about the recordings of the webinar series, which are being uploaded onto the BICL website as we go. So every week, the recording of the webinar that takes place that week is uploaded to the website. I also wanted to remind everyone that if you have questions, please do use the Q&A function that you can find on your screens. Please do ask questions as we go. We do promise to try to get to all of them, even if time might not allow us to do so. I am sure that all the speakers will be appreciative of the comments and the feedback, and that they will take them to heart and address them as they speak or after the session if there isn't the time to do so during the session itself. And having said all that, it is my great pleasure to welcome Dr. Ioane Antonopoulos as today's chair. Ioane is a lecturer in law at Royal Holloway, University of London, as well as being a visiting fellow at BICL. She holds a PhD in law from the University of Aberdeen, and her research interests cover the two angles that will be discussed today, three angles, so migration, human rights, and environmental law. Ioane, over to you.
Thank you, Jean-Pierre. Good morning to everyone. Good afternoon. It's a pleasure to host this today. We're marking a year, the year anniversary from the Human Rights Committee decision on climate displacement, which is a better thing to remember than the rest of 2020. And I'm in great company today to discuss the implications of the case, its significance, and the surrounding issues when it comes to this case. So today with me, we will have Emmeline Siale-Lolahia, CEO of the Pacific Islands Association of NGOs, whom will be joining soon, Senior Professor Jane McAdam from the University of New South Wales, Atmas Habteslasi, a barrister from Landmark Chambers, Professor Benoit Meyer from the Chinese University of Hong Kong, and Matthew Reid QC, also from Landmark Chambers. Thank you all for being here with me today. We will start with Professor McAdam, who will be discussing a bit of the background of the case and the issues that surrounded the case in relation to climate displacement, refugee, and human rights law. Jane.
Thank you very much, Ioane. And hello, everybody. I'm delighted to join you from Sydney, Australia. And before I begin, I'd like to acknowledge the traditional owners of the land on which I am, the Camaragal people of the Eora Nation, and acknowledge their elders past, present, and emerging. Well, it gives me great pleasure to join you today to discuss a little bit about the Human Rights Committee decision in Teitiota and New Zealand. The matter in which the Human Rights Committee recognised that it's unlawful for states to deport people to countries where the impacts of climate change expose them to life-threatening risks. I plan to use the case as a springboard into some of the legal questions arising in situations where people resist return to their home country on the basis that the effects of disasters or climate change will make it too dangerous or intolerable. In terms of the background to the matter, it concerned Mr. Teitiota from the small island state in the Pacific of Kiribati. After overstaying his work visa in New Zealand, he'd sought to remain there on international protection grounds, arguing that life in Kiribati was increasingly precarious on account of the effects of climate change. After a series of unsuccessful appeals in New Zealand's tribunal and courts, he was deported to Kiribati, at which point he lodged a complaint against New Zealand with the Human Rights Committee. Now, on the one hand, the Human Rights Committee's decision was a landmark determination. It was the first time that a quasi-judicial body had stated that, and I quote, "without robust national and international efforts, the effects of climate change may expose people to life-threatening risks or to cruel, inhuman, or degrading treatment, thereby triggering the non-refoulement obligations of sending states. Furthermore, the committee said that states have a continuing responsibility in future cases to take into account new and updated data on the effects of climate change and rising sea levels." So this not only means that as climate impacts worsen, future similar claims might well succeed, but that potentially even now, a different person somewhere in the world might already have a valid protection claim. On the other hand, though, the committee's decision wasn't a legal revolution. The underlying legal principles were already well established. There was a good 2 decades worth of domestic decisions in Australia and New Zealand in particular, considering the relevant issues. And scholars had long pointed to the capacity of the principle of non-refoulement under human rights law to protect people in this context. And furthermore, the point I haven't yet made clearly is that on the facts, the committee found that there had been no violation of Mr. Teitiota's rights. The significance of the decision then, in my view, lies in the Human Rights Committee's explicit recognition that the impacts of climate change may themselves be a bar to removal, as well as in its authoritative nature, which I think will have influence on future jurisprudence and potentially also on policy making. In terms of current international law processes, it will feed into the work of the International Law Association and the work of the International Law Commission, both of which are examining issues relating to the protection of people affected by sea level rise. So to turn to the broader context, why all this matters is because already each year more people are displaced within their own countries by disasters than by conflict. 75% versus 25%. And these numbers are likely to rise as climate change increases the frequency and/or the intensity of natural hazards. Existing international legal instruments do not directly address the movement of people who cross borders in response to or in anticipation of climate change related harms, although there's not a complete legal void. It will generally, but not always, be difficult for such people to be recognised as refugees under the 1951 Convention. And although it's not impossible, there certainly are some challenges. Even though there's no such thing as a climate refugee, as the media so loves to portray, there is such a thing as a refugee whose circumstances are made worse because of climate impacts. The ILA's Sydney Declaration of Principles on the Protection of Persons Displaced in the Context of Sea Level Rise, which was adopted in 2018, explains, and I quote, that while the underlying disaster or climate change process will not constitute persecution per se, it may provide a context in which forms of harm that do engage international protection regimes may arise. For instance, where the disaster causes a breakdown of law and order, or is used by a government as a pretext for persecutory acts against certain parts of the population. This view was reflected and developed in a document released last October by UNHCR, in which it emphasised the importance of understanding climate change impacts in a broad social and political context. As legal scholar Matthew Scott has argued, we must appreciate the deeply social nature of disasters, within which existing patterns of discrimination and marginalisation are exacerbated. Now, in New Zealand, Mr. Teitiota's refugee claim was unsuccessful, and in fact, he dropped this part of the claim. He conceded he didn't have an argument there. Human rights law arguably offered him more scope, both in terms of the right to life, which was the focus of the Human Rights Committee's analysis, but also the right not to be subjected to cruel, inhuman, or degrading treatment. The Human Rights Committee emphasised that the right to life includes the right of individuals to enjoy a life with dignity, which necessarily requires a certain standard of living. But to avoid being removed on this basis, Mr. Teitiota would have had to show that, and I'm quoting now from the committee's views, that the inadequate supply of fresh water was inaccessible, insufficient, or unsafe, so as to produce a reasonably foreseeable threat of a health risk that would impair his right to enjoy life with dignity or cause his unnatural or premature death. And similarly, with respect to his claim about difficulties in growing crops back in Kiribati, he would have had to show that there was a real and reasonably foreseeable risk, and I quote, that he would be exposed to a situation of indigence, deprivation of food, and extreme precarity that could threaten his right to life, including his right to life with dignity. And because he couldn't establish either of these things, among others, the claim didn't succeed. Now, in my view, this threshold is too high when a range of rights are impacted as opposed to just one. So if it had just been a lack of fresh water supplies, then arguably the threshold might have been appropriate. But when it was that on top of crops, on top of shelter, on top of a range of other things, then I think a cumulative assessment is far more appropriate. And that's already part and parcel of refugee law, for example. Another aspect that the committee didn't address, and which would have been very interesting, was had it looked deeply at the question of cruel, inhuman, or degrading treatment. That is Article 7 of the ICCPR. Now, the reason it didn't was because Mr. Teitiota didn't raise a claim on that basis. But I think it would have been interesting to see how the committee would have approached an Article 7 claim in assessing whether the conditions in Kiribati could be said to amount to cruel, inhuman, or degrading treatment, because that might have prompted a slightly different analysis from the Article 6 right to life claim. It also would have been interesting had the claim been brought on behalf of Mr. Teitiota's children as well, because some further interesting questions could have been explored, including whether in assessing their rights, a longer time frame for analysis might be entertained. Indeed, the question of when harm needs to manifest for removal to be precluded has been a subject preoccupying me for a number of years, along with my colleagues, Professors Michelle Foster and Hélène Lambert. In the Teitiota matter, the Human Rights Committee accepted, and I quote here, that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. But they concluded that Mr. Teitiota did not face, again I quote, a real, personal, and reasonably foreseeable risk of a threat to his right to life on the facts presented. Now, what's reasonably foreseeable will depend upon context and evidence. In Mr. Teitiota's case, the committee accepted that sea level rise was likely to render Kiribati uninhabitable, potentially within 10 to 15 years. However, it endorsed the New Zealand Tribunal and Court's reasoning that risks 10 to 15 years into the future were too speculative to give rise to a protection need now, since this timeframe could allow Kiribati, assisted by the international community, to take affirmative measures to protect and, where necessary, to relocate its population. A relevant consideration was also the fact that the government of Kiribati was already taking adaptive measures to reduce existing vulnerabilities and to build resilience to climate change-related harms. This reasoning requires scrutiny. In refugee law, for instance, and by way of analogy, protection may be warranted even where there's only a 10% chance of harm, provided that the risk to the individual is plausible. The scientific predictions with respect to climate change go well beyond a 10% risk. However, the science also supports the committee's wait and see approach, given equally authoritative projections that innovation and transformations in economic, social, technological, and political actions may mitigate some of the risk. But with Michelle Foster and Hélène Lambert, as well as our co-author Adrian Anderson, we've argued that the focus shouldn't be on the certainty of harm, but rather whether there's a real risk of that harm. And we argue that a mere possibility of intervention or the potential of mitigating developments may not be sufficient to reduce an existing real risk, albeit one that will manifest in the distant future. In other words, people shouldn't have to wait until their lives are imminently threatened. And as the Human Rights Committee itself recognised, conditions may become incompatible with the right to life with dignity before the risk is realised. And as one committee member noted, it would be counterintuitive to the protection of life to wait for deaths to be very frequent and considerable in order to consider that the threshold of risk had been met. So what then should we conclude from all of this? The Teitiota case has helpfully clarified the application of the principle of non-refoulement in the context of climate change-related harms, building a clear line of authority from the national to the international level. But while international law has a distinct role to play, it certainly doesn't provide all the answers on its own. We need a far broader and bigger toolbox of responses at the local, national, sub-regional, regional, and global levels to address mobility in this context, as set out, for instance, in the Sancin Initiative's protection agenda 5 years ago. Measures include facilitating disaster risk reduction and climate change adaptation so that people can stay in their homes for as long as possible when that's what they desire, as well as wider structural reforms that would allow people to move in advance of harm. Things like harnessing migration as a form of adaptation. There are also good practices to learn from. David Cantor has shown how in the Americas, for instance, existing immigration law offers a number of different options to people. Tamara Wood and Arma Francis have examined how free movement agreements likewise can assist people to move without having to invoke displacement paradigms. And Pacific governments, including Fiji and Vanuatu, have adopted internal relocation guidelines to facilitate dignified movement as a strategy to avoid future displacement. Implementing such approaches would not only accord with the commitments that governments have already made under a range of international and regional frameworks, but it would also align with their own interests in creating more planned, manageable, and regulated processes for movement. Thank you for your attention.
Thank you, Jane. That was very, very interesting, and thank you for giving us a background into the case as well. I want to remind the attendees that you can start from now asking your questions. We'll have a chance at the end to look at your questions, and the panelists will also have an opportunity to react to each other's presentations. So I would like to invite you to start asking questions from now. Next presentation is from Matthew Reid QC, who will discuss the case and its significance and its impact, and how we foresee to have a more impact in the future. Matthew.
Thank you very much, Ioane. I'll endeavour to get my slides up. I hope everybody can see that. Ioane, can you see my slides? I hope you can.
Yes, I can.
Thank you very much. Well, thank you very much for allowing me to speak. And Jane, thank you for indicating the background of the Teitiota case. I'm going to go into the Teitiota case in a little more detail in the slides, and then deal with the significance of the decision. And I hope I'll be forgiven for repeating some of the matters that have been already dealt with by Jane. But I do it because I can then set out why I think it is of some significance as a decision, and indeed aligned with what Jane has said. But in terms of the development of any jurisprudence in this particular area, the significance of it as a decision is questionable. So if I deal firstly with the facts, as Jane said, there was a claim made by Mr. Teitiota, described as the author, of course, in these sorts of decisions, that there had been a breach of Article 6 because of the risks which he, and to be fair, his family, so it was taken into account to an extent, his family's position, would face as a result of the effects of climate change. And of course, having gone through assessment by the immigration officers and then further applications to court by way of applications for leave to appeal, which were all ultimately dismissed, the author was ultimately deported to Kiribati. The communication had been made to the committee just before his deportation and raised, as Jane has said, a number of specific aspects. And if I deal with those, albeit bearing in mind the significance of the situation in terms of Kiribati being, as it was and is indeed at the moment, no more than 3 meters above sea level. Those aspects were the violence over land disputes, inability to find land to provide accommodation for himself or his family, an inability to grow crops, a lack of access to water, overpopulation, and then frequent and increasingly intense flooding and breaches of seawalls as a result. So those were the fundamental points that were raised on the author's behalf. And it was also said, and this is an important point that I'll come back to, that there'd been a failure to introduce, in terms of the government of Kiribati, programmatic steps to provide for the basic necessities of life to meet the positive obligations that exist on and are placed upon the Kiribati government to fulfill the author's right to life. Now, one of the background points with regard to the author's complaint was that on returning to Kiribati, one of his children contracted an illness from drinking water, a point that actually one of the minority opinions that was delivered in respect to this case highlighted. Now, the decision, of course, was that whilst the communication was found to be admissible, there was more than a theoretical possibility of impairment of the right to life. Ultimately, the facts did not permit the conclusion that New Zealand's decision to remove the author and his family violated his rights under Article 6. So that was the ultimate conclusion that had been reached. Now, I'll deal with the majority reasoning in order to explain why I think the decision has some significance. But before looking at the majority reasoning in detail, I touch on the question of admissibility, because when one's looking at the committee's assessment, there needs to, of course, pass the threshold of admissibility. And the committee was clear that there was a situation here where we didn't have a hypothetical future harm. There was a real predicament or risk caused by the lack of potable water and employment possibilities and a threat of serious violence. So in terms of actually what had been described, it overcame that particular hurdle. But it's really the communication that the committee was considering, and the communication needs to establish that there's either arbitrariness, manifest error, or injustice in the state party's evaluations of the author's claim. And one needs to bear that in mind, because whilst there is a substantive decision as to whether or not there's a breach of Article 6, it's couched in that context, and it's within that framework that the decision is to be read. Now, the risk that one needs to establish, one that the author had to establish, was that it had to be a personal risk, and it can't in the usual way derive merely from general conditions in the receiving state, except in the most extreme cases. And one can see that in the general comment 36 of the committee on Article 6, and I've given the reference, which you'll be able to see later on. But that is an important aspect, and it must be imminent. At least that was the state party's position. It isn't actually reflected in the decision itself of the committee, which is, as Jane has indicated, a consideration as to whether or not there was a reasonably foreseeable harm that would and had to be taken into account. Now, the committee reiterated environmental degradation can adversely affect an individual's well-being and lead to a violation of the right to life. Something, again, I'll come back to, but had been made very clear in earlier decisions as to the significance of that particular aspect. And Agnes, I expect, is going to deal with that later on. But looking at the committee's reasoning in more detail, what this really was a decision that the required level of proof had not been established. And looking at it from the perspective of a practicing lawyer, that was the real error, or rather the real shortcoming in the case that was presented, and which led to the committee not accepting the position. And so looking at each of those violent land disputes, there was an absence of general conflict in Kiribati, and the author had never been involved in such a land dispute. That's what the committee decided. There was a lack of evidence of state protection against or rather a lack of evidence of a lack of state protection against non-state actors who engage in violence and disputes. And it hadn't been demonstrated as a result that there was a clear error in New Zealand's assessment of there being a reasonably foreseeable threat to his right to life. Lack of potable water. I'll come back to this in the context of a minority decision, but the committee noted, as Jane has said, that the conclusion of the New Zealand authorities that there was no evidence that the author would lack access to potable water was essentially accepted, albeit but that it was concluded that there was insufficient information indicating that it was inaccessible, insufficient or unsafe in the ways that Jane has indicated. So on the basis of that lack of evidence, there was a conclusion reached that there wasn't a breach of Article 6, the lack of land to grow food. The author's case actually was that it wasn't impossible to grow food, it was just simply difficult. There were other forms of, there was a lack of evidence rather of other forms of employment and availability of financial assistance. And you can see from that just how much or what level the committee was saying needed to be established in evidence in order to overcome the threshold in order to establish an Article 6 contravention. And nutritious crops remained available in Kiribati. Again, not therefore a real and reasonably foreseeable risk. Increased flooding. The committee here accepted that the risk of an entire country becoming submerged underwater is an extreme risk, and so extreme that you can have a situation where there would be incompatibility with the right to life and the right to life with dignity in a country before you get to an absolute position. But the committee accepted, and the committee accepted that the author's case on sea level rise is likely to render Kiribati uninhabitable. It wasn't absolutely clear that it accepted the 10 to 15 years as the timescale, but it didn't seem to actually, certainly didn't say that that was wrong. But that time frame, if it existed, was sufficient, as Jane has said, to allow for intervening acts by the Kiribati government. So whilst there's a continuing responsibility on the state party, a point I'll come back to take into account future deportation cases. In those cases, the situation at the time in Kiribati with new and updated data, which actually was a clear indicator, I think, that they are not going to be held to the conclusions that they have so far reached on the facts in this case, and that in other factual scenarios, there could be a different decision. It ultimately said there wasn't a breach of the Article 6 rights. So I deal with the summary of the situation and as I said, inherent in assessing whether there's a breach of Article 6, one needs to look as to whether or not there would be a real and reasonably foreseeable, and I say imminent risk, that the author's life would be threatened in any of the ways envisaged, and there was not. Now, there were minority opinions, and I'm conscious that we've got a limited amount of time that I can speak on this, so I don't want to deal with all of what I say in the slides, and I hope you'll be able to read them when this presentation goes up on YouTube. But I do just want to highlight Mr. Muhamuza's points, because he was saying, well, look, actually the threshold should not be too high, and this, I think, reflects something of what Jane has said. It shouldn't be too high, it shouldn't be unreasonable. And that in the circumstances of Kiribati, actually the difficulties in being able to find fresh water, the difficulties associated with growing crops, the health hazards to the author's child, those matters that now actually engage the right to a life with dignity and breach it. The Sancin Opinion took a different approach, but nevertheless reached the conclusion that there was here a breach of Article 6. And the reason that she gave is because what, and I say at the bottom of this slide, what had been found was that by the UN Special Reporter on safe drinking water in 2012 was that Kiribati's national strategies for water resource improvement have yet to be implemented. So on that basis, what actually needed to happen was for the New Zealand authorities, in the light of that, to be satisfied that there was actually a demonstration that the that the author would enjoy access to safe or potable water in Kiribati. That had not been shown, and in circumstances where it hadn't been shown, there would be a breach of the positive duty to protect life. So it was an evidential point, a point that I'll come back to in a moment. So what then are the matters of significance? Well, there's an evidence issue, as I've said already, and Jane has referred to. Critical to the decision was the lack of evidence of a real and imminent risk in any of the ways alleged. But of course, in a clearer case, something, as I've said already, the committee recognised that could be overcome. Now, the Sancin approach of essentially a reversal of the burden of proof, which it could be read as amounting to, is an approach that could be taken. But it seems to me that that's not justified on the jurisprudence. There still needs to be the making out of the relevant aspects of Article 6. Is it a new point? Well, I don't think so. The subject, that's the effect of climate change, is clearly significant, but it doesn't actually derive from new analysis. As I said, the general comment, number 36, made clear the connection between climate change and the right to life. Now, there is a point about persecution under the Refugee Convention as to whether or not the potential for that can happen without direct human agency. Now that, it seems, at least my reading of the New Zealand Tribunal's decision, the Immigration Protection Tribunal's decision, was that actually one could have that. I don't hold entirely to that view, but in a sense it doesn't much matter because there can be indirect human agency as well. That, again, is not a new point. What I do think, though, is important is the relationship between state responsibility and the imminence of risk. And that's what the committee focused upon. Were the steps sufficient to avoid the risk? Now, they took pretty much a mechanistic approach to that. There were steps in place, they could be taken, therefore the risk wasn't imminent. One needs to focus, I think, strongly on the extent to which actually state action is available to avoid the risk in circumstances where there is an inevitable situation, as there was in Kiribati, at least on the evidence, of a 10 to 15 year potential destruction. Now that position, as I say, had already been reached for the purposes of Kiribati from the perspective of Mr. Muhamuza. But that's, I think, an important aspect to bear in mind. So the significance, landmark decision, of course, because of what it was directly dealing with. But is there a change in approach? Actually not on the jurisprudence. The Article 6 jurisprudence is sufficient to be able to deal with the arguments that are being made. And the question is whether or not there needs to be anything changed under the legislation or by way of domestic decision making to actually engage with and accommodate climate change. As I say, I don't believe there is. The matter can be dealt with under the existing position. It really comes down to the evidence, and it comes down to the extent to which it can be proved that there is an imminent risk. And that, of course, is something actually that has, as Jane said, been something that tribunals have accommodated. The New Zealand Immigration and Protection Tribunal, in terms of the Tuvalu case, had looked at this issue in the context of humanitarian issues and taken it directly into account. So that, it seems to me, is the position as we find it. I hope that's been helpful, and if any queries arise from it, of course, I'll be happy to answer it. I'm going to stop sharing now if my technological abilities allow it. Yes, they have.
Perfect. Thank you, Matthew. That was extremely interesting, and it kind of shows some of the limitations that we were not communicated, especially by the media as well. Some of the limitations of this case. Professor Benoit Meyer will now discuss state responsibility in climate migration. My understanding is with a bit of a critical eye, but I will, Benoit, you're next. Thank you.
Thank you very much. I'm unmuted. Okay. So thank you very much for having me. Good day from Hong Kong. So I'm going to present a slightly different perspective on this topic, perhaps one which is more centered on climate law as opposed to refugee law to some extent. So my argument is, I think, not critical as much as skeptical, but we'll come back to that. basically, out of these three concepts, climate change, migration, and states' obligations, you could frame my argument in a nutshell as being that you can't put the three concepts in one sentence and make sense. You can make sense with two concepts, but not with three of them. In my view, the climate migration discourse is addressing a phenomenon which is not a natural phenomenon. There are two different ways of approaching the climate migration nexus, two different kind of arguments which have been merged and confused, leading to this discourse. The first argument is a human rights argument. States have to protect the rights of, in particular, the most vulnerable individuals, including migrants. There's nothing about climate change in this argument. The second argument is that state responsibility is a state responsibility argument. States have an obligation not to cause harm to one another, and if, or to the extent that some states are responsible for climate change, they have to pay some reparation, they have to perhaps pay some compensation, or in other way make reparation to the countries most affected. Here again, I don't include the three concepts. There's nothing about migrants in the second argument. So what I will argue is that if you take the human rights argument, you can't include climate change in the argument in a consistent way. If you use the state responsibility argument, you cannot speak about migrants. So the human rights argument, the argument is that states have treaty obligations or other obligations to protect various human rights, including the right to life, the right not to be tortured, and so on. Those include positive obligations, obviously. The states have to take measures that address particular situations of vulnerability. And clearly there is a need for particular policies, and there's a possibility of interpreting human rights treaties as requiring particular policies addressing the vulnerability of migrants, forced migrants, refugees, and so on, or people displaced within their country, or people exposed to natural disasters. However, climate change does not cause distinct situations of vulnerability which require different forms of human rights-based policies. The concept of climate migrants does not mean anything that can be implemented in practice. We cannot identify climate migrants. I will come back to that. But even if we could identify climate migrants, even if we could distinguish them from other migrants, then it remains that climate migrants are not in, or would not be in a different situation of vulnerability requiring different forms of protection. They would fall within other categories of migrants with specific protection needs: international migrants, domestic migrants, people displaced by natural disasters, people temporarily displaced, displaced permanently, and so on. So the first part of this argument, the fact, I think, that climate migrants is not really a concept which can be implemented. We cannot identify climate migrants because there is no simple causal relation between climate change and individual migration. Climate change causes changes in physical events. There are more natural disasters, there is a sea level rise, and so on. So sometimes you can allocate, or you can attribute a physical event to climate change in the case of sea level rise, but most of the time you can't really, because saying that there are more cyclones because of climate change does not mean that one particular cyclone can be attributed in a binary manner to climate change. There are not different natural disasters caused by climate change. Climate change is an exacerbating factor that increases certain types of physical events. And even if you look at sea level rise, which is perhaps a stronger case, sea level rise can be attributed to climate change, most of it, but it does not directly impact societies or individuals. It interacts with other factors in complex ways. The sea level rise that displaces or affects societies is the relative sea level rise at the particular location, which does not depend just on the sea, but also on the land, subsidence, and other phenomena. Many of the islands we are talking about are moving naturally up and down because of different volcanic and subsidence phenomena. And even to the extent that a physical event can be attributed to climate change, it remains that there is no natural disaster. Every disaster affects individuals in a social, political context. Individuals are displaced because a phenomenon happens and they are not protected, they are vulnerable and exposed to this phenomenon. And this is not just me. So you didn't have the arrow before. So that's the illustration of my point. So that's not just my point, it's also expressed by some relevant authorities. One of the most, I think, influential reports on environmental change and migration by the Foresight Agency in the UK in 2011 concluded that it will rarely be possible to distinguish individuals for whom environmental factors are the sole driver or would be environmental migrants. The IPCC's latest assessment report concluded that it is difficult to categorize any individual as a climate migrant. This is not about terminology. This is not something that can be solved by changing the way we speak about this population, not as climate refugee, but as climate migrant, or as, I quote, people displaced by the impacts of climate change. In either case, you still suggest that there is a population that can be identified and treated separately, which the IPCC has said is not the case. But even if it was the case, even if we could identify climate migrants, I think it remains that those populations will not have to be protected in a different way. Human rights apply to everyone in the same situation. The cause of vulnerability is not relevant. What is relevant is the situation of vulnerability, the protection needs. And I agree that the Refugee Convention itself has this problem. It does not make much sense to define an international migrant worthy of international protection or refugee as someone who is displaced because of persecution for one of the 5 grounds. That does not make sense. It's arbitrary. And I think there is a need for a critique of the Refugee Convention, but de facto, there has been an extension of the protection of refugees much beyond this convention definition. So there remains, of course, important loopholes in the international protection of migrants, of forced migrants. I'm not saying that the law is perfect, it is not. I'm just saying that the concept of climate migration is not the fix that we need. I really like the concept of survival migration that Alexander Bates has suggested, a concept which will apply to anyone who is migrating abroad because of life-threatening circumstances, of whichever cause. It does not matter whether it's related to climate change or not. And I read the views of the Human Rights Committee in Teitiota as not really focusing on the impacts of climate change or on the on a causal link with climate change. The applicant really emphasized on climate change. But when you look at the latest paragraphs where the committee provides its own analysis of the law and its application to the facts, the emphasis is not on the causal relation with climate change. It is just you have an individual who, if sent back to his country, will be under a situation of vulnerability because of environmental circumstances. There's no link with climate change here, and the link would simply not be relevant to the decision. It is not a material element to the decision. A question here would be whether climate change may cause new scenarios of migration. And so I've been thinking about that for some time, but really I don't think it does. It's most of the time exacerbates various types of migration. I think the most important statistical impact of climate change on migration is on economic migration. Climate change has impacts on the development of different countries or different regions, which in turn creates some economic push or pull for migration. So there are more people migrating probably because of this indirect impact of climate change. on push and pull factors of migration. But that does not make it a different scenario of migration. Then migration may be triggered by natural disasters, but here again, it might be the case that climate change increases the number of natural disasters and therefore results in more people being displaced. But there's no difference in scenario or in need of protection if someone is displaced by a typhoon, whether or not the typhoon is related to climate change. Now, what about sea level rise? So there is, it's quite difficult first to attribute an individual migrant to sea level rise. And that's, I think, the issue that the Human Rights Committee had in that case of Teitiota. Sea level rise is a very gradual phenomenon. We don't see sea level go up at once. What will affect people more directly will be a particular typhoon or a particular high tide, which is more likely because of climate change. But it's very difficult here to attribute an individual migrant to climate change. There are, it's again, so is this a different type of migration that you don't see in other contexts? I don't think it is. Look at Jakarta, capital of Indonesia. Jakarta is now a place of out-migration, massive out-migration because of subsidence, which is probably partly exacerbated by climate change, but the clearest, most active factor is subsidence because of the pumping of fresh water underground, which makes the city get down and get flooded. So whether people are displaced because of sea level rise or because of subsidence does not make any difference in terms of the treatment that people should be provided. There should not, in my view, be any distinction between people displaced out of Jakarta or people displaced out of the southern coast of Bangladesh. Those are people experiencing the same situation of vulnerability, even so from different causes. What about sinking states, so the Kiribati, the Maldives, Tuvalu, and a few others? I think we need to first keep in mind that this is a very small part of the impact of climate change. We are speaking about the Kiribati and Tuvalu will be about tens of thousands of people. The Maldives is slightly bigger. We speak about hundreds of thousands of people, but that's really very small compared with the populations affected by climate-related impacts, for instance, in Bangladesh or in other countries. Second, we don't know what will happen with this population in Tuvalu or Kiribati. The solution is probably not an individual protection status on a case-by-case basis for those of the population of Kiribati who happen to be in New Zealand at a particular time. The solution is probably something that involves the state as a sovereign entity and perhaps a reclamation of land or the grant of land or some artificial land or some other solution. I don't think that looking at the problem from an individual case-by-case perspective would be a good solution. So that's the first argument on human rights, the human rights argument, which in my view does not justify a specific protection of climate migrants. It justifies a protection of all migrants from whichever cause. But this argument tends to be merged with a second argument, which I call the state responsibility argument, according to which states have responsibility for causing climate change. This argument can be made on the legal plane or on the moral plane. I'm not distinguishing here. I'm just looking at the possible argument. I'm not making the argument either. But you could argue that states have various treaty or customary law obligations or even human rights obligations to protect the rights, even so there is no individual affected by the violation. Even so you cannot identify a particular victim, there may still be a human rights obligation to protect the population as a whole. Or you can have, of course, a moral argument of the same sort. Of course, some of the impacts of climate change could be considered as the consequences of the failure of particular states or perhaps even one state to comply with those legal/moral obligations. And there could be an argument that the responsible states will have an obligation to make up for the harm they are causing to other states. But there's nothing about migration here. And the first question, if you want to try to transform that into an argument for the protection of migrants, is who is affected by the wrongful act of some states. And the public international law response would be states, not individuals. Public international law provides reparation to states when a state causes an international wrongful act. It does not provide reparation to individuals. And if you add this to the difficulty before of identifying individual harm caused by climate change, I don't think there will be any possibility of reparation for individuals. The reparation will be directed to states if there are any reparations. Will climate, even if you do believe that there will be a category of climate victims that will require some kind of individual reparation, then my question would be, will climate migrants stand out as a particularly affected subcategory of climate victims? And here you have to keep in mind that those individuals who migrate are usually not the worst off. Those who migrate are those who can migrate, who have the resources, the money, the know-how, and the contacts to go somewhere else. I'm not sure about the situation of Mr. Teitiota, but usually most refugees are well-educated, well-off individuals. It does not mean that we should not protect them, but it means that this is perhaps not the most pressing protection need in a human rights perspective. There has been a lot of publications about the displaced in place or the population who are not able to migrate. So most of the most vulnerable individuals will remain within the country or within the place of origin. When people do migrate, however, we have to keep in mind also that they usually stay within the same country. So therefore, international protection will be a very small exception. And when they cross an international border, they usually cross it to go to the next country. So they will usually remain in developing countries. They will not usually go to the countries most responsible for climate change. Therefore, providing a non-refoulement to a specific category of climate migrants will not really impose responsibility on the states most responsible for climate change. It will, to the contrary, impose most responsibility on the states most affected by the impacts of climate change. It will require a country like Bangladesh or Kiribati or the Maldives to comply with additional obligations instead of providing those countries with reparation. So it will do the exact opposite of what state responsibility would suggest. So that's the argument I wanted to make, put it in a kind of provocative way. But in my view, there's really no consistent, rational way of making an argument for the protection of the rights of climate migrants or people displaced by the impacts of climate change, because those are not a distinguishable category of population, because they are not in a particular situation of vulnerability, and because state responsibility will require the states responsible for climate change to provide reparation to the states most affected by climate change and not to impose new obligations on those states most affected by the impacts of climate change. Thank you very much.
Thank you, Benoit. Again, very, very interesting. I would like to remind everyone that they can ask questions, although lots of questions are already coming in. That will keep us occupied after the final presentation. But please do send your questions and we will address them after the presentations. Atmas Hatteslasi will discuss the state of international law in relation to climate displacement. And we are looking forward to your presentation, Atmas.
Thank you. I hope that I am audible, and I will now attempt to share my screen. I hope that everybody can see that.
Yes.
Excellent. Thank you very much. I'm going to be talking about international law, international human rights law, a little more broadly, but essentially following on from the discussion. And the focal point is going to be human rights protection, which places limits on expulsion where that would constitute a breach of the individual human rights, the individual's human rights, basically the Teitiota situation. And I'm going to focus on the European Convention on Human Rights. I'll briefly mention the advisory opinion of the Inter-American Court a couple of years ago, which makes some interesting points about causation. The position, it won't surprise anybody to hear that the law's very underdeveloped. That's really why we're all here. But I'm going to try and identify some pressure points where I think the law could develop. Certainly the European Court and associated persons and extrajudicial statements and otherwise have indicated an interest in using the convention in particular to protect climate change, so we can have a think about how that might play out. And I'll also touch on some dreaded causation and responsibility issues. So the ECHR is generally considered protection, or its protection has been extended to harm to the environment in the context of Article 2, the right to life, and Article 8, the right to home, private life, and family life. We won't need to concern ourselves too much with Article 8 in this talk, because that's not generally considered to impose obligations based on the conditions in the receiving state. And where Article 8 breaches arise in removal and deportation cases, it's because of the Article 8 rights that people have in the sending state. However, there is a reasonably well-developed case law on environmental harm, which I will just touch on by way of analogy a little later. Of more direct relevance is Article 2, the right to life, which was the right that was also in play in Teitiota, which imposes an obligation not to deport where the home country would entail a real, where removal to the home country would entail a real and concrete risk of exposure to a life-threatening situation covered by Article 2. So we all, I'm sure, are familiar with the classic situations where that arises. There is a parallel and much more widely relied upon duty under Article 3 in the context of torture and ill treatment. In terms of the, just to set out that the approach that the European Court would generally take, there have to be substantial, and it's worth emphasising that Article 2 and Article 3, the principles are generally treated as interchangeable. There has to be substantial ground for believing that the applicant faces a real risk. There's a focus on the foreseeable consequences of removal to the country of destination, in light both of general situation there and the personal circumstances of the applicant. Where the question is a general situation of violence, the threshold is correspondingly a little higher. So it has to be sufficient, well, it's only of sufficient intensity to create such a risk in the most extreme cases, is what the Strasbourg Court said, where there was a real risk of ill treatment simply by virtue of an individual being exposed to such violence on return. So that's the position in principle in relation to Articles 2 and 3, entirely independent of questions of climate change. In terms of how climate change has arisen in relation to Article 2, in order to understand that, the focus, we bear in mind that the focus of the Strasbourg Court has been on positive duties under Article 2 rather than the negative prohibition. And the two of the duties that are said to arise under Article 2 and also Article 3, which are relevant, are a systems duty to put in place appropriate legislative and administrative framework, including making regulations to compel institutions to adopt appropriate measures for the protection of people's lives, so making sure you have the system in place, and what's termed alternatively an operational or protective duty from the case of Osman in the UK, when that involves to take preventive operational measures to protect an identified individual from Article 2 harm. That latter duty is heavily caveated by a warning that disproportionate burdens should not be imposed on contracting states. So duty to put in place systems and to protect. And the European Court has found respondent states to have breached the operational duty to protect persons from environmental harm in a number of cases. I'll just highlight a few examples to give a flavour. Death resulting from an accidental explosion at a rubbish tip close to a shanty town. Loss of life caused by a foreseeable mudslide. Serious risk of life due to a heavy flash flood. Death as a result of prolonged exposure to asbestos in a government-run shipyard. So those are all examples of a situation where environmental harm has been found to form a basis for a breach of the right to life by the Strasbourg court. So where does that take us in terms of displaced populations? Well, one immediately identifies something of a conceptual problem in that those breaches tend to be based on the positive operational or protective duty, and that is a positive obligation that is imposed on a state in relation to its own jurisdiction, where it has the control commensurate with a logic to impose such obligation. On the other hand, the non-refoulement obligation not to return a person to another state arises in a quite different context, being the state's right to exercise immigration control and to remove people who don't have status. And it's really for those reasons, or arising from that context, that the threshold for unlawfulness is quite high. The breach is not in how the state has arranged matters within its own jurisdiction, but in exposing the individual to the risk of harm at the hands of a third party, another state. And these are understandably generally considered distinct aspects of Article 2 and Article 3. And that's important because the right to life and the engagement of the right to life by climate change is going to arise in terms of breaches of positive duties. It's not going to be the analogy isn't going to be with state entities killing somebody unlawfully or torturing someone unlawfully. The analogy is going to be with a failure to put in place measures. So how do we go from the non-refoulement obligation to a breach of a positive obligation in another state, which for the purposes of a regional instrument such as ECHR may not be a party to that instrument? One interesting category of cases which may provide something of an analogy is Article 3 deathbed cases. So these are cases where the Strasbourg court has essentially found a breach of Article 3 where somebody is very ill, receiving treatment in the sending state, and deporting them or removing to another country is going to increase the risk of them being exposed to ill treatment by virtue of their illness. There's an extract here from Papashvili which summarizes the position. So these are described as cases where the applicant faces a real risk of rapidly experiencing intense suffering to the Article 3 standard in the receiving state because of their illness and the non-availability there of treatment which is available to them in the removing state. The boundary of Article 3 protection has thus been shifted from being defined by imminence of death in the removing state, so that was earlier case law, to being defined by the imminence of intense suffering or death in the receiving state, which may only occur because of the non-availability in the state of the treatment which had previously been available in the removing state. So what's the relevance of that to climate change displacement? Well, that's a pretty clear example where the two duties that I mentioned earlier, the positive protective duty and the non-refoulement duty, seem to be being brought together, because the risk of a breach of Article 3 arises not from the applicant being subjected to torture, for example, by the state authorities, but it's a breach, something that is or would be or could be a breach of an Article 3 positive obligation, that is to say, to provide for treatment sufficient to prevent Article 3 suffering in the receiving country. That country may not, and invariably is not going to be a well, not invariably, but in most cases, is not going to be a Council of Europe, a ECHR contracting state. So it's really an example of a non-refoulement obligation arising from what's seen to be a breach of a positive obligation in the receiving state. So the question that arises, and this is essentially the approach that was taken by the committee in the Teitiota case, is why couldn't a similar approach be taken where there's a breach of the Article 2 operational protective duty in the receiving country on the basis of environmental harm? For my part, I don't see any difficulties of principle with that analysis. I don't see, I can't think of any insuperable issues of principle to an analogy with those cases. Well, what kinds of issues could arise? No obstacles in terms of the analogies I've mentioned. In terms of bringing harm from that would lead to climate displacement within the protections of the European Convention, there is this is reasonably well accepted in the Article 2 and the Article 8 context, and as I touched on earlier, there is an expressed willingness on the part of the Strasbourg Court to bring the protection of the Convention to bear on climate change issues. The Strasbourg Court will also interpret the Convention in light of rules of international law, relying on the Vienna Convention, Article 31.3c, but there's also some more bespoke principles that it applies in the regional context, and of particularly glaring piece of context is the Paris Agreement, which is the first environmental treaty to refer expressly to human rights, at least in the preamble. So that's all part of the context. So in my view, there's no real difficulty in the position of principle. The issues that arise are more in the nuts and bolts, and they've been touched on already in the talks here, showing individual harm to the requisite threshold of severity and imminence. There is a threshold already in the Article 8 case law, makes it clear that the adverse effects of environmental pollution must attain a certain minimum level, and that's a fortiori in the Article 2 and 3 context, where the prohibited treatment is significantly more severe. And there's already been some discussion, particularly in Matthew's talk, on the challenges involved there. But we're essentially talking about evidence on the one hand and persuasive analysis on the other. And there is, and this is a complex issue in and of itself, but one of the questions that arises is, well, isn't the case that the harm could always be avoided by adequate intervention on the part of the state? I don't think there is a neat answer to that, and I think it will turn simply on, as a matter of policy, what approach is taken, how generous or stringent a threshold the court would apply to this particular category of harm, being environmental harm. The other issue that arises is causation and responsibility. The Article 2, Article 8 breaches are very localized. The ones that have been made out very localized. There's no real dispute about causes. Non-refoulement based will be based on a general risk, for example, rising sea levels, and that raises more problematic causation issues. And I note the very interesting points made by Professor Meyer in his talk. I think ultimately it will be resolved again as a matter of policy. It will be a question of, or legal causation. What's the threshold that the court is going to settle on in view of the nature of the harm? There have been attempts to rely on Article 47 of the Law Commission's Article of Responsibility, and those have generally been deprecated by the Strasbourg Court in the context of jurisdiction, where it's been attempted to use that as a gateway for jurisdiction. As a good example, and the Ahombai admissibility decision, which I've cited there. But causation is, I would say, a less loaded issue when it's not the basis for jurisdiction. You're not where one is not arguing that the responsibility of the state is the trigger for the ECHR applying at all. Or the question that's being asked, the causal question that's being asked in the non-refoulement context is a more humble one, really, which is, can this harm be attributed or be conceptualized as an Article 2 or an Article 3 harm? And that I would say, doesn't really require the Strasbourg court to get into nuts and bolts of who's responsible. All you need is harm to reach a certain threshold, and for that harm to be of a nature that should be protected by the ECHR. I'm just flagging, I'm conscious of times, I'm just flagging the Agostino case, which is pending before ECHR. This isn't a non-refoulement case, certainly as far as I understand. It's a direct responsibility case where the applicants are complaining that all 27 EU countries plus Norway, Russia, Switzerland, Turkey, UK and Ukraine have failed to comply with positive obligations under Article 2 and 8 and also 14, read in light of Paris, and the contribution by each state's greenhouse gas emissions means that there is a shared responsibility. So I don't know this for a fact, but I suspect Article 47 will be in play in those arguments. Rather interestingly, on communicating the case, the European Court of Human Rights asked the parties to comment on Article 3 and also Article 1 of Protocol 1, protecting possessions. Just really, it's notable that the European Court of its own volition took an interest in Article 3. And what's striking in the context of our discussion is that there's a clearer route there to the non-refoulement analysis. It'll be certainly one to keep an eye on. I'm just going to touch as a kind of concluding point on the advisory opinion of the Inter-American Human Rights in relation to the request made by Colombia that was issued in 2018. The question there was about whether infrastructure works creating the risk of significant damage to the marine environment created liability under the American Convention on Human Rights. So this isn't a non-refoulement case, but what's interesting about it is that the court took a rather expansive approach to the issue of responsibility jurisdiction. So the jurisdictional clause is pretty similar to the Article 1 of the ECHR, requires respect and securing of the rights therein. There is a express protection of an environment in an associated instrument, the Protocol of San Salvador. And the court essentially concluded that where transboundary harm or damage occurs, the persons under the jurisdiction of the state, if there is a causal link between the action that occurred within its territory and the negative impact on the human rights of persons outside its territory. Its approach to the human rights analysis is just very interesting. It took very much the approach of saying that one has to look at human rights altogether as protecting one another, and that the right to environment is something of a precondition for other rights. And there are some analogies there with the approach in Strasbourg to Article 2, the argument that you need to be alive, otherwise the other rights in the convention are of little worth. I've just set out there a couple of paragraphs where the court summarises the main paragraphs on responsibility. If there's a causal link between the act that originated in the territory and the infringement of human rights of a person outside its territory, it is the state in whose territory or under whose jurisdiction the activities were carried out that has effective control over them, and the potential victims of negative consequences are under the jurisdiction of the state of origin for the purposes of the possible responsibility of that state for failing to comply with its obligation to prevent transboundary damage. It reads to me as a very broad approach, and I suppose its relevance to our discussion in terms of the non-refoulement context is in the move to a framework for human rights liability in relation to environmental damage. And so that, in a sense, gives credence. It's a backdrop that gives credence and respectability to the non-refoulement arguments based on environmental harm. So just to summarize in terms of, well, I suppose I should say that for my view, I mean, I would agree with Matthew's analysis in that I don't think it is a particularly big leap to develop the non-refoulement case law into the climate change context. I think that the conceptual apparatus is already there. We've got non-refoulement, we've got analogies we can draw with non-refoulement and the approach to protection under Articles 2 and 3. The difficulties are in terms of establishing severity, imminence, and impact on an individual basis of harm. and causation, but the causation issues, as I've said, diminish somewhat given the less important role that plays in the context of the non-refoulement approach. Thank you all very much. That's the end of my talk.
Thank you, Ioane. This was fascinating. I'm trying not to abuse my position as a chair and ask you questions now. So I will start with the audience's questions. Stacey addresses, is asking a question for all the panelists. Small island developing states, such as Barbados, are disproportionately affected by climate change. How can such small countries gain standing in the international arena in order to pursue climate change litigation? Jane, shall I ask for your input into this?
Thank you, Irina. Look, that's actually one of the only ones that I feel I don't have a really substantive contribution to make. So there might be somebody else working more directly on the litigation who wishes to respond. Thanks.
Of course. Matthew.
I see the point. It always will come down to the position of particular individuals when one's looking at it from a human rights perspective. And when one looks at it in that context, there should be then the ability to engage in litigation in order to establish a breach of one's human rights, of that particular litigant's human rights. So I take the point that there are going to be some countries that are disproportionately affected, of course. But I come back to where I was before in terms of my talk, which is that these sorts of issues are all capable of being dealt with within the current human rights context. And so long as the particular case arises, say, in respect of a refugee argument, there will be the ability of that particular individual or those individuals to make good their claims. One would, from my perspective, the legislative framework is there in order to pursue these sorts of aims.
Thank you. Professor Meyer, there are two questions specifically addressed to you, and they relate to this issue you mentioned about causation that you all kind of discussed. But the first question says, with regard to sea level rise as a cause of migration, surely that is a little more clear-cut than the other examples, such as increased extreme weather events. What else could cause sea level rise in relation to the timescales that we're talking here? And then the next question kind of discusses similar issues. Would it not be useful still to identify climate-induced migration or climate migrants as such?
Right. So on the first question, I agree that sea level rise is a stronger entry point to look at the argument on climate migration. I still don't find it very convincing because it's just one factor of migration that causes people to have to move and to have to be in a situation of vulnerability. There are situations of coastal flooding that are not, or for which sea level rise is not the dominating factor, the prevailing factor, like Jakarta, where it's mostly a local land subsidence, which operates much faster than sea level rise. But even when, why would sea level rise have to be addressed differently from other slow onset environmental changes like desertification, which may or may not be related to climate change? I think that's my response. I think we need to protect all migrants who are displaced because they don't have a choice but to go somewhere else, and they should be protected. The reason why they have to move is interesting. It should be taken into account in predicting what kind of migration flow we would be expecting, but it should not be the decisive or a relevant factor in deciding who to protect and how. On the second question, sorry, could you remind me the second question? That's the end of the day here. That's also, yeah, I've got it. Yeah, on the political advocacy argument, right? What if the concept of climate migrant could help to change things? And for long, I have been kind of thinking about that. It's also a very strong argument. Now I think it's a red herring. in the sense that so first, I think our role here at the BIICL or as academics is not advocacy, it is knowledge creation. And that's what I'm trying to do in my scholarship. I'm trying to create knowledge to be frank and objective as much as I can, and not to present things in a way which I believe will push for the political change I want. I think that's really important to keep that in mind, that we do not have, a scholar, we do not have more legitimacy than anyone else in political governance, if we believe in democracy, at least. I don't believe in the government of experts. But putting that aside, if I change my hat and become an advocate for the rights of migrants, from which the question is, I think, as opposed to an advocate for climate change mitigation. So then there is the possibility as well that it could go the other way. It could become a red herring, as I believe the protection of refugees has been. James Hathaway had the argument that in the 1940s, the international protection of refugees has basically reinforced the emerging rule that states do not have to accept international migrants unless they are refugees. So the protection of refugees has become an exception which reinforces the rule of the absence of obligation towards international migrants. And if we keep defining exceptions, we're not addressing the issue, which is the rule. The rule should be that international migrants, forced migrants, survival migrants should have some rights, and those rights should be protected, notwithstanding the cause of migration.
Thank you. Jane, do you have anything to add on this?
Yes, thanks for that. Look, I think just on the point about this last point, attempts to define the concept of a climate migrant, climate refugee, whatever, in a legal sense have been very problematic and ultimately quite unhelpful, I think, particularly where there's a causal link sought to be made with climate change for the reasons we've already discussed. Climate change amplifies risk. It is always a multi-causal phenomenon, but that's not to say that we shouldn't look at climate change at all, because of course it can be an underlying reason or an interacting reason why people are at risk, or why particular vulnerabilities they might have are made even worse. So as I said before, there's no such thing in law as a climate refugee, but there certainly are refugees whose circumstances are more precarious because of climate impacts, and likewise people who aren't refugees but who find themselves in difficult situations. And I think for me, the focus on the rights that are at risk is why we look at, is the right to life jeopardized? Does the cumulative impact of harm constitute inhuman or degrading treatment? And it's focusing on the rights as opposed to what's caused them. That's a separate type of litigation if we want to attribute harm or responsibility to particular countries. I think it's really that line of argument is unhelpful in the protection context where the focus is on rights. Just on the advocacy point, Francois Germain wrote a really interesting piece in the Forced Migration Review in 2015, lamenting the fact that he thought some scholars had been too quick to dismiss the climate refugee label precisely because of the advocacy points. So that's interesting. And I think just as a general point, for a wealth of material on this issue, the Platform on Disaster Displacement website collates a lot of really important stuff. So have a look there. On the question about statelessness, if I may, there was a question whether if Kiribati does become uninhabitable, its population would become stateless. And I think the short answer is no, and there are a number of reasons for this. For a start, the very strict legal definition in the Statelessness Convention is somebody who is not considered as a national by any state. So unless the state were to formally deprive its citizens of nationality, which would be unlawful here, the statelessness definition would really only be triggered if there were no state in existence anymore. And that is a highly speculative and convoluted legal argument that would basically require us to look at the reverse of the creation of states. But I mean, I don't have time now to go down that line, other than to say, in reality, this isn't how it's likely to happen. People are going to have to move long before territory is inundated. So it's more likely that the descendants of Kiribati, for instance, will already have moved somewhere else and potentially even have obtained citizenship of another country before the land of Kiribati disappears. And there's ongoing work by the ILA and the ILC around all these issues, both the sea level rise aspect, territory, and the statehood and protection questions. And just a final point on that, from a purely practical perspective, the statelessness treaties aren't well ratified. Not many countries have a formal stateless status determination procedure in place anyway. So, you know, I think there are a number of reasons why that avenue isn't really helpful. Look, I'm wary of the time, so I'll hand back to you, Irina.
Thank you. I have a question for Atmas. I found your point about Article 3 very fascinating, and that all of a sudden we see the Strasbourg Court having an interest in Article 3, whilst the tradition in relation to environmental matters in Article 3 before the Strasbourg Court was that they wouldn't really touch it. So do you see the approach of the European Court of Human Rights completely changing with climate change cases and kind of separating from what they decided in environmental cases, in light of, you know, some of the issues raised in Urgenda and so on?
Yeah, well, I think there are a lot of similarities between Article 2 and Article 3, obviously, in the way that the Strasbourg Court approaches them. And it's always dangerous to try to be a mind reader, isn't it? But it seems to me at least possible that the Strasbourg Court would, for example, say, to the extent that environmental damage, environmental harm might generate Article 2 issues, it can also generate Article 3 issues, depending on the nature of the harm. I can see that doesn't seem to me to be a very difficult analytical step for them to take. So that's my sense on one view. The problem is that it's counterintuitive. Just if someone just read Article 3, it's counterintuitive to go to its relevance in the environmental harm context. But it's been interpreted pretty broadly, and so there seems to be no reason for me to go down, no reason for the Strasbourg Court not to go down that road.
Well, there's hope. I think we have time for one last question. And there is one question from Kim. Would a multilateral public international law solution, such as a global compensation fund for adaptation and mitigation, be an effective and complementary alternative avenue for the protection of climate refugees? A simple example of this is sketched out in the Compensation Fund of Climate Impacts. Jane?
Thank you for this. Well, I mean, I think a broad point first is to say compensation's not enough. There's so much that can't be compensated, particularly if it comes ultimately to issues of self-determination, cultural heritage and the like. That's not to say, of course, that compensation wouldn't be welcome. On that, I should note that this isn't compensation so much as funding. The Green Climate Fund doesn't directly mention mobility, but you know, a large number of projects have been funded that do relate to mobility. On a more domestic point, Fiji has established a climate relocation and displaced persons trust fund for communities and infrastructure. The New Zealand government, for instance, has put money into that. And that what they talk about, or what that relates to, is internal relocation. But you know, there's an example where an affected government has taken matters into its own hands. I guess the final point that I'd make, though, is that the protection paradigm is really only one aspect of very many in our toolkit. So there are lots and lots of proactive measures that governments could be undertaking right now that aren't hard. Things that are really simple, like having building codes in place that are enforced. That saves lives. Having proper evacuation planning, that saves lives. Most people will never cross an international border. So by and large, the phenomenon we're talking about is one of internal movement. And that's where I think the global community certainly can support with financing and technical assistance. But, you know, we're not talking about most people on the move having to deal with a lot of the principles that we've been talking about today. And while some certainly need protection, others need options to move, options to migrate with dignity.
Thank you very much. And I think it's a great achievement that we managed to answer all of the audience's questions. We heard some very interesting presentations. Unfortunately, our last speaker couldn't make it for technical reasons, but I want to really thank you for your input and the work you have put in your presentations and your talks and addressing our audience's questions. I will hand it back to Jean-Pierre.
Thank you very much, Irini. I'm conscious of time, so I will just take 1 second to once again thank all our speakers today, and thank you, Irini, for convening, but also chairing so we did the session today. And then just a kind reminder to our participants that the next and final webinar in the series will be today week, with the minor difference that unlike the today's and the last two webinars, the webinar next week will be at 5 p.m. UK time. Rather than at 9 a.m. UK time. And with that said, thank you very much to the events team. Thank you very much, Liam. Thank you very much to Landmark Chambers for their support of this webinar series. Thanks to the speakers. Thank you, Irini, and have a good day, everyone. Or a good night.
Thank you, everyone.
Benoit's cases. Thank you very much. Goodbye.